Hello everyone, welcome to the channel Unlock Law Online English. Today I am here with a different conceptual video. That is, I am reviewing a movie, a very legal perspective. It's not on the bit of story or something like that. And the movie that I'm going to review legally is Patna Shukla. The movie Patna Shukla has highlighted the biased treatment that is faced by a female advocate in society. She is constantly pulled down by quoting that she is only good at kitchen, good at affidavits, good at drafting, etc. She doubts her own caliber and considers herself to be a tiny ant. However, a series of events, the drawing by her son, wherein an ant lifts a mighty elephant, she gets motivated and it finds place in her work table as a framed picture. It signifies the importance of family and shows the role of son, father, and husband in a female's life. And also, the source of motivation could be anything. It need not be a motivational speech, lecture, or something like that. It could be an action done by us or anyone without even that person knowing. My topic here is the question of law involved in this movie. Rinki approaches advocate Tanvi to get copies of her answer sheet as she believes that she could get more marks. If Rinki would have approached me, I would have simply asked her to file an RTI application at Bihar University or wherever she was studying. Now, justifying my legal advice to her, let's answer these two questions. The first question is whether answer script or paper is covered as information under RTI Act of 2005. Second question, whether university, either private or government, are covered under public authority under RTI Act of 2005. Quoting CBSE versus Aditya Bandopadhyay case, it was held that the definition of information in Section 2, Clause F of RTI Act refer to any material in any form which includes record, documents, opinion, papers, among several other enumerated items. The term record is defined in Section 2, Clause I of the said Act, including any document, manuscript, or file, among others. When a candidate participates in an examination and writes his or her answer in an answer book and submits it to the examining body for evaluation and declaration of the result, the answer book is a document or record. When the answer book is evaluated by an examiner appointed by the examining body, the evaluated answer book becomes a record containing opinion of the examiner. Therefore, the evaluated answer book is also an information under RTI Act. In ICAI versus Shaunak Satya, it has also been held that the copies of evaluated answer paper cannot be under any exemption prescribed under RTI Act. In Manish Goel versus Union Public Service Commission, the Central Information Commission held that this right to get copies of answer sheet could not be denied. In Alka Mathuria versus Maharaja Ganga Singh University and others, it was held that having regard to the purpose of the enactment and the nature and purpose of the provision herein, we are of the view that even if the respondent university were to make independent regulation for the purpose of providing certified copies, so far the fields covered by the Rajasthan rules of 2005 are concerned, the respondent university cannot make any such regulation that could stand at conflict with such rules. The regulation framed by the respondent university deserves to be quashed as illegal, and the respondent university deserves to be directed to provide a certified copy of the answer book to the petitioner after charging the fees prescribed under the Rajasthan rules of 2005 and not that beyond. Moving further, in ICSI versus Paras Jain, the Honorable Supreme Court has held that both Right to Information Act and Company Secretaries Act 1980 has provisions for applying certified copies of answer sheet. The Honorable Supreme Court held that if a candidate seeks information under the provisions of right to information, then payment has to be sought under the rules therein. However, if the information is sought under the guidelines of the appellant, then the appellant is at liberty to charge the candidate as per its guidelines. Further, in Abne Ignati versus CPIO, Delhi University, New Delhi, the Central Information Commission held that and directed all the universities in India, including deemed universities and all examining bodies, to provide copies of answer sheet only at a cost of rupees 2 per page and make necessary changes to their respective notification accordingly as soon as possible, but not beyond 30 days from the date of this order. Further, it was directed by UGC and Association of Indian Universities to circulate, publicize, and insist on implementation of this order in all academic or examining bodies, and directed the Ministry of Human Resource Development to circulate this order to all examining bodies, including universities, and make it mandatory for them to bring uniformity in the rules and regulations by fixing cost at not more than rupees 2 per page of answer sheet. Hence, Indian courts and CIC, Central Information Commission, has unequivocal terms held that evaluated answer is an information under Right to Information Act. Now, the second question, whether private universities are covered under public authority. Definition of RTI Act. Let's read out the definition. Public authority as per Section 2, Clause H reads as public authority means any authority or any body or institution of self-government established or constituted by or under constitution, by or any other law made by the parliament, by or any other law made by state legislature, by notification issued or order made by appropriate government, and including any body owned, controlled, or substantially financed, non-governmental organization substantially financed, directly, indirectly by the funds provided by the appropriate government. Keeping this definition in mind, let's see what University Grants Commission, UGC, has to say about this. So, giving a background of UGC, it is a statutory organization of Government of India by an Act of Parliament in 1956 for the coordination, determination, and maintenance of standard of teaching, examination, and research in university education. Hence, irrespective of the fact that if it's the government university or private university, it shall be governed by UGC. It states that all universities and colleges established by law made by parliament or by state legislature or by notification by the appropriate government or owned, controlled, or substantially financed or directly or indirectly by funds provided by the government shall come within the meaning of public authority under this Act. The University Grant Commission has brought private universities under the scope of RTI Act 2005, which means the private universities can't hide information about the students' fees, admission, faculty appointment, and other details. Now, coming back to the facts that was associated with the movie Patna Shulka. So here the easiest and the most appropriate way that Advocate Tanvi could have followed to get the answer copies of the client of hers is to file an RTI application, and if not heard, follow the appeal procedure as defined under this Act. The law is well established here, and also the courts that are being chosen and the method that was being followed is not appropriate. I personally feel that this is misguidance that is provided to the students because they form the larger part of the audience, that to get the answer sheets, it is this difficult and it is not easier for you to get the answer sheet or also to fight for the justice. Hence, I appeal or I request with all the movie makers, filmmakers to review the storyline in a legal perspective by a person from law background so that these things does not happen, and you provide the right information to your viewers and the citizens of our country. Thank you for watching.